Good morning, everyone. Thank you so much for joining us today for the second webinar in the series on reporting the courts. Today's webinar will cover how to navigate the courts, and I will now hand over to Mr. Hopal Radebe from the SANEF office to do the welcoming remarks. Thank you.
Good morning, colleagues. My name is Hopal Radebe. I am with the South African National Editors Forum. We thank you so much for joining us again on our second webinar. Last year, December, we did the first webinar, which was looking really at the basics of the courts and what has changed and the structures that have over time evolved. This is the second webinar which our colleagues, and we are doing this in partnership with the Institute for the Advancement of Journalism, the IAJ. They will be looking at how we navigate the courts. I think I should just remind many of you that we did update the manual, which was done more than 10 years ago, and a lot of laws have evolved, have changed the system, and we therefore were requested by many interest groups that if we could look at updating this manual and looking at how the courts have evolved over time. And with the blessings of the IAJ, of course, we are now making sure that we are training those that are willing to sort of refresh themselves about our legal system, and in particular, the courts in this country. On the sideline, SANEF is still getting involved with a lot of how we get access to the courts. You know, the COVID-19 had changed a lot of rules of how people could go to courts. We now have to apply before we are able to get to courts. We now have to, you know, just for people to get access to it, there are a lot of rules that are happening. So we're busy working with the Office of the Justice, Chief Justice, sorry. We are also talking to the presidents of each region of the courts, just to make sure that the issue of an open court system does not get compromised, be it with the presence of COVID or not. So enjoy these lessons. I myself I'm tuning in to make sure that I update and upgrade and see how it is that it's new that is happening out there. And I'm looking forward to this lesson. I hope you you enjoy it. So I'll give back to our colleagues. Thank you so much.
Thank you so much, Hopal. At the IAJ, would like to thank yourself and SANEF for giving us the opportunity to do these webinars. We do feel that these webinars are of importance and will be very informative and helpful to journalists. So I will now hand over to our very capable facilitators, Dianne Walker and Candice Bailey. Thank you.
Thank you so much, Tishan. And good morning, everybody, and welcome. Dianne, are you there?
I'm here, yes. Good morning, everyone. All right, let me start with a quick introduction about myself for those who don't know me. My name is Dianne Walker. I am the video news editor at Times Live. I was part of the Arena Group. But in my previous life as a journalist, I spent a lot of time covering courts. I started out as a High Court reporter at the Cape Argus, and essentially was thrown in the deep end, as I'm sure many of you were, asked to cover cases without much of a grounding or understanding about how the system works. And then I went on to work at the Sunday Independent, where I also did a lot of court reporting, as well as at ENCA. I covered a lot of the big court cases, including the Oscar Pistorius trial, as well as the Aurora mine saga. So court reporting has really been my bread and butter. I do still dabble in it from time to time. I'm really looking forward to the Judicial Service Commission hearings, where they are meant to appoint sort of discuss who's likely to be the next Chief Justice. And I hope all of you will also keep a close eye on that process, because our next webinar on the 16th of Feb will actually look more closely at judges, how they're appointed, and also the role of the Judicial Service Commission. So that's it from me. I'll hand over to Candice.
Thank you so much. Dianne, for those of you, just a little quick introduction to myself. My name is Candice Bailey. I've also been a journalist. I've worked at pretty much many of the same places that Dianne's worked at. Besides for ENCA, I've been a journalist for about 19 years. Started off in Cape Town, and I'm currently the Strategic Initiatives Editor at the Conversation Africa, which is a platform that tries to make academic work more accessible to the lay audiences. I am going to head straight into the rest of the webinar, just so that we can get going. We are a little bit behind time. And I hope that you enjoyed the session with us today. Just a bit of an outline about our program, how it will get going. We've had a welcome by SANEF and by the IAJ. We'll run very quickly through the webinar objectives, what we hope to achieve by the end of the session today. And then we'll touch on a few specific areas in our webinar: hierarchy of the courts, important court processes that you should understand, the Criminal Procedure Act, and how you can improve your reporting. And I'm very excited about this section of the webinar, particularly. We'll have some insights from different players in the judicial system and across the people who work in the court system, and how you can improve your reporting as a court reporter. And we'll then just end off within an hour, we'll end off with some closing remarks by the IAJ. So just to give you a rundown of the objectives of what we hope to achieve in today's session. So the way we structured the webinar is to help you understand and navigate the actual court system. We understand that as court reporters and as people who cover cases within the court, you often have to go to different courts, and you need to understand how they work, what the hierarchy is around them, and we want to give you a good understanding of that. We also want to give you a good understanding of the Criminal Procedures Act. It's a very important piece of legislation in terms of court reporting, and you need to understand how that works when you are reporting on different cases. We want to give you some insights into the processes of the law, such as bail applications. We'll cover some more of that later on. And then we'll just give you the tips, as I said, on how to improve your reporting of the court system. So our webinar today is structured a little bit more different than the previous one. If you had attended our previous session, it was a basic seminar that Dianne and I hosted, and we were speaking to you. In this session, we've brought in some interactive elements. We've brought in some videos where we've spoken to key players in different sectors of the court system, if I can put it that way. And we are hoping to play these videos for you and hope you can get some insights into them. The first video is coming up in the next minute. And in this video, we are introducing you to Yvonne van Niekerk. Now, Yvonne van Niekerk works in the Office of the Chief Justice, and she's the person that's responsible for ensuring the smooth management of the court system across the court. In this, she looks at the case management, case flow. She looks at, she makes sure that all the different players speak to each other, and she's really just a critical part of the judicial system. I'm just going to go over to the video, and you can take it from there. We can discuss after.
Many of us have found ourselves here covering an important court case without full understanding of the best way to proceed. The jargon is flying at you suddenly: accused, witness, Schedule 6 offense, bail application.
Sorry, everyone. Seems like we're having a bit of a technical difficulty there. Let's try that one more time.
Sorry, guys. Can you hear the video now? Let's try that one more time. Sorry. Now, Anne, will you just give me a thumbs up if you can hear the video? I'm just
Will do.
1 second.
Many of us have found ourselves here covering an important court case without full understanding of the best way to proceed.
Candice, the volume's gone again.
I'm not sure why it's giving us a challenge. I can get it perfectly on my side. I think Dianne, can we try it one more time? Let's just try it one more time and we see. I'm not going to touch my computer at all, and let's see if we can play it. Okay, let's try last time lucky. Let's hope for the best.
Many of us have found ourselves here covering an important court case without full understanding of the best way to proceed. The jargon is flying at you suddenly. Accused, witness, Schedule 6 offense, bail application.
Sorry, everyone. I don't know why, but it does seem to be cutting out. I think what we'll...
The geographical area in which they can operate, and then also in the
Okay, just pause it. Sorry about that, everyone. The technical gremlins appear to have caught us out today. The video actually was working really well when we tested this morning, but it seems like for some reason it's not playing along with us as we would like it to. I think Candice will just try and see if she can resolve the issue. But what we'll do in the meantime is I'll just talk to some of the main concerns or the main issues that we spoke to. Yes, I see that there's a suggestion that we send a link for the video. So what we'll do is that we will send a link for the video, and we'll also ask the IAJ to actually put the videos up on their platform. The videos, there's actually a couple of videos, and I'm not sure if we're going to have the same challenge with all of them, but in the meantime, what I'll do is I'll speak to basically what the key points are that we wanted to touch on in relation to the hierarchy of the system. If I could just ask that the other participants just make sure that they are muted in the meantime, just so that we can have, you know, one meeting. So, you know, the main thing that does tend to trip a lot of people up when it comes to covering the court system is, you know, how they actually navigate and go through the different levels of court. Now, there are different, there's the lower court level, which involves the magistrate's court. And then there's also the sort of superior courts, which involves the High Court and the Constitutional Court and the Supreme Court of Appeal. And there's an important distinction between these different levels, which also comes into play when it comes to your actual reporting. Now, the magistrates court level, they have various district courts, and the court manual that Hopewell mentioned actually gives quite a detailed breakdown of these different courts. It tells us that there are over 384 magisterial districts, and those are figures from 2018, and over 1,914 magistrates in South Africa. So if one looks at that, one can see that the magistrates court system is actually a massive part of the overall legal system. And it's actually the part of the court system that most people, ordinary citizens, actually interact with on a daily basis. The magistrates court deals with all kinds of issues, from petty theft to initial court appearances of accused when they first appear in court. And that's often the first time that many of you will be going to court, would be at a first appearance of an accused. They do also deal with some civil matters, but only dealing with lower amounts below 200,000 Rand. And basically what this means is that if you have a minor issue where perhaps somebody has taken some of your money, or you've lost a possession and you actually want to sue someone, you can take it to the magistrate's court as long as the amount is below that 200,000 rand. The lowest level of the lower court system is actually the small claims court, and you don't even see magistrates there. You actually see more commissioners who act as mediators, who are able to deal with cases. So oftentimes they'll deal with rental issues and minor disputes of very low amounts of money. And then when we look at the superior courts, it starts at the High Court, but it's also very important to note that the High Court has a number of subsections. So there's the High Court that we all go to, and South Africa actually only has one High Court. It's called the High Court of South Africa, and then it has sort of, you can think of them as branches located in different parts of the country. So you'll have the High Court sitting in Johannesburg, or the High Court sitting in Cape Town. And that's an important distinction, because it means that really any case can be heard that takes place or that affects any issue across the country within the High Court. The High Court is also the area where you see a lot of civil court cases taking place. And those of you who attended the previous webinar will recall that we spoke about civil cases as another important part of court reporting, because oftentimes there will be legal challenges to legislation, there will be legal challenges to something that government has or hasn't done, and those will oftentimes start at that High Court level, and then they can make their way up further into the Supreme Court of Appeal and to the Constitutional Court. Now, the difference between magistrates court level and the High Court level, which is quite important to recall, is that magistrates sit at the lower court level and judges sit at the higher court level. So you've got, judges sitting in the High Court, and then from the Supreme Court of Appeal and the Constitutional Court, they are referred to as justices. And that's a distinction that sort of helps to indicate their seniority as it goes with the just different judges. I think another just important note to make also about the superior courts is that there are some specialized courts that you find at High Court level. So the Labor Court, for example, is one of the specialized courts that you would find at the High Court level. Another specialized court that you would also find at the High Court level is the, I think, Candice, if you don't mind going to the next slide, no, the previous slide. I'm just before this point. No, oh, sorry, no, go further. Yeah, beyond the video. Yes, sorry. So you've got several specialized courts, such as the electoral court would be a specialized court. The labor court would also be a specialized court. And they are at a High Court level, but they are given a particular kind of provenance and a bit of separate infrastructure. And part of the reason is that in certain instances, there's different legislation that actually regulates these courts. But also, if you think about labor issues, for example, there are a lot of labor conflicts, people who are unhappy with their employers who are unhappy with their staff. And even after those things go through things like the CCMA, you might find that then beyond that, they end up within the labor court. The land claims court is another example of a specialized court. And that court was actually set up at the dawn of South Africa's democracy, partly because there were so many disputes about land ownership in South Africa. It's not one of the courts that we see often covered at present, unless there are something that is a particularly large case. But that being said, it does deal with some very important issues, considering South Africa's history and issues relating to land. Now, I did speak a little bit about the different types of judicial officers that was in the previous slide. And I'm going to just touch on a little bit about some of the other key players that you will see in the court system, and also how they differ in how they operate. Many of us have come in contact with prosecutors in court. They are amongst the key players, especially in criminal court proceedings. Most prosecutors are also, they would be advocates. And oftentimes they are reluctant to speak to the media That's mainly because of the NPA's kind of rules and regulations. But prosecutors do tend to be very important sources for journalists because they're the people that hold the main information relating to the criminal court case. What are the people being charged with? What are the witnesses? Who are the witnesses that are meant to be coming in this court case? And it's often a good idea to make friends with the prosecutor in any case, even if they are reluctant to speak on the record. Get to know them, introduce yourself to them, make sure that they know who you are, what publication you're there from, and also just glean relevant court information from them. This will really help to improve your court reporting because, like I said, they are the main suppository of information relating to what is going to happen in the case. Attorneys, you will often see on the side of the accused in a criminal proceeding, or they would be representing someone in a civil case who is involved, whether it be the person who's bringing the case or the person who's the respondent. And the attorney is oftentimes the public-facing person. You'll see the attorney giving interviews. You'll see the attorney speaking on behalf of the client. Part of the reason is that advocates are not really allowed to speak in the media in terms of their regulation. Some of them do end up speaking publicly, but it's definitely a bit frowned upon within the advocate's profession for advocates to be speaking in the media. So oftentimes if you go to court and you see an advocate arguing something and you want to ask them something, they'll say to you, I'm having difficulty here. Am I still on?
We can hear you fine, Dan. You can continue.
Oh, that's really weird. Okay. So basically they are sorry, I've just lost my train of thought because I got a strange message saying that I'm signed into another device, which I'm really not. Okay, let me just continue. So basically what they are, the advocates are the main drivers really of the case. They are the ones that would find the strongest legal angles. They do extensive research. The instructing attorney, I always think of them sort of as the strong quarterback or the strong one of the strong team players, but they don't always get the credit. They're not always at the front on the front line because they are not always the ones, especially when it comes to a very serious matter or a high profile case. They are not the ones that are always arguing up front, but the attorneys are as important in the legal proceedings as their counterparts, the advocates in the case. And they are also the people that most oftentimes you will get information from as a journalist to actually find out what is going on in the case. Now, there are also some other important players that exist within the legal system. And you might find yourself also having to cover their work or their involvement in the case or in court cases. For example, you will find that the Department of Justice is not necessarily involved in the criminal proceedings, but they offer key support to bodies within the justice system. So, for example, the Department of Justice has the budget for the National Prosecuting Authority. And one of their responsibilities is, of course, to help with ensuring that there is a well-functioning justice system. That includes ensuring that there are sufficient prosecutors and making that budget available. They cannot interfere with the work of the National Prosecuting Authority, but they are enabled to actually help the justice system to function at an optimum level. Another name that you'll see coming up quite a lot is the Public Protector. Now, the Public Protector has powers that actually are quite similar in some ways to judicial officers, in that they can make a ruling and their ruling is binding after they've completed an investigation. Those kind of rulings can be taken on review, like what we've seen recently with some of the major cases where rulings are taken on review. But if the court finds that there's no reason for them to review the Public Protector's ruling, that ruling does then become a binding finding from the Public Protector's Office. And I think it's very important to note that, because the Public Protector's Office unlike other judicial processes, does offer an important avenue for ordinary South Africans to actually approach someone who can fight on their behalf. You don't necessarily need a lawyer, for example, to go to the Public Protector's Office. You can just write a letter and detail your complaint, which will then be go through its investigative process, and the Public Protector is then able to actually decide whether there's something to investigate. Once they've investigated, they are then able to actually make a finding, and there is remedial action that they can offer, like, for example, saying that money should be paid back, as we saw with the Jacob Zuma incident, or to actually say there should be further investigation because perhaps they didn't have enough time or opportunity to investigate a particular issue sufficiently, or to even recommend criminal prosecution in some other cases. So they are a very important aspect. As a Chapter 9 institution, they also have an overlap with the criminal justice system and the justice system overall. One other thing that I also wanted to just point out is the Master of the High Court. And this is an office that often, it took me a bit of a while to figure out how do they actually fit into this whole thing. The Master of the High Court, you often encounter them when it comes to sequestration applications or liquidation. Now, if you have found yourself covering a case where, for example, a company is accused of not paying a creditor, for example, that company might be liquidated. And essentially what that means is that the creditor will come and say, these people owe me money, and I need the court or the Master of the High Court to help me to get my money back. And then the liquidation process ensues, and the Master of the High Court actually oversees that process. There are liquidators that the Master has on their roll. The liquidators are tasked with basically looking at what the situation is as it relates to monies owed, who's owed, how much are they owed, and also identifying the certain creditors. That in itself is a sort of could possibly be a webinar on its own. But what is important to note is that that process also ends up in the High Court. So a liquidation won't just happen out of thin blue air. There would have to be an application to the High Court requesting the liquidation. And that's where the Master of the High Court is brought in. The Master of the High Court's office must ensure that the funds are not squandered, that competent liquidators are actually appointed. The liquidators must also give a report to the Master of the High Court. And these matters do tend to come up in important court cases. And I'll give you an example. You all remember the Bosasa matter of not too many years ago. And Gavin Watson and his counterparts were said to have not paid some of their creditors. And as a result, the company was liquidated shortly after his death. Now, that whole process is obviously still ongoing, but in it, you will find the stories of who is said to be owed money, where the money might have gone to, for example, and also who is likely to take over the goods once they are auctioned off by the Master of the High Court. So that process does tend to come up as quite a key aspect in court proceedings from time to time. Is there another slide on key players, Candice?
No, that was the last slide. I've been working very hard behind the scenes to get our videos up and running. So what I am able to do now, we're going to head over to the next video on bail. There's a question that maybe you can just flag this in the chat that you want to just answer while I take off the screen and then prepare the bail video for playing. And I hope that now that I've taken it off the presentation system, it should work correctly. So you go ahead, and I'm just going to stop sharing. Go into the video. So
Catherine's question relates to the regional, the difference between the regional court. So Catherine, you are right. It is a magistrate's court at this point. And you'll recall that I said that the magistrate's court is often what they call the court of first instance. So what that basically means is that most times a case will start at the magistrate's court, but it won't continue all the way. The magistrate's court, you can think of them almost as the first stop on the journey through the court process. Once it gets to a point where it's actually closer to trial and it deals with matters that involve large sums of money or very serious crimes such as a murder, then it will basically graduate to the High Court level. And you know, the way I sometimes think about it is that, you know, there's so much happening within the court system that the system doesn't want to bog down the High Court, which deals with a lot of different matters, with an incomplete case, because we will sometimes find that while it's still at a magistrate's court case, there'll be a number of postponements. The NPA might say, we are still doing investigations, and then they'll postpone. Or they'll be dealing with a bail application, and the bail application will take several days or weeks, and they'll postpone. So when it graduates to the High Court level, and it has to do with either a large sum of money or it has to do with a very serious crime, then most times that case is pretty much ready to go. And that's when the NPA and the investigating officer have the majority of their ducks in a row. They'll get to court, and they'll usually have something that's called a sort of like a case flow management meeting, where they will have a discussion about dates and stuff like that. And then the actual proceedings will begin. So I hope that answers that question. I think we're going to try and give our video one last try. Hopefully it works this time around. I'm just going to mute so that Candice can take over on that.
So I'm not putting on the initial video and the hierarchy of the court system. I think we're running out of time. So we're going to move into the bail video, which I think segments really nicely from what Dianne has just explained to Catherine's question. And we're going to go into the video. We do apologize for the technical difficulties earlier. And what we will do is we'll ask the IAJ to put these videos on their website as well as their YouTube page. And maybe they can tweet them out as well. And you can then have a look at them at your own time. Here we go.
When it comes to courts, I think the area that concerns me the most is reporting on especially bail. There is a public outcry every time an accused is granted bail. I think the journalists can play such a good role in educating the public as to what the purpose of bail is. Bail is something which everyone has the right to ask for court in terms of the Constitution and in terms of criminal process. Is that everyone is then brought to court, and because the thinking of detaining someone after they've been arrested on suspicion of committing a crime is that we need to detain them to ensure that they appear before court, because the ultimate aim is to ensure that the matter is resolved, and in a criminal case that a guilty verdict or a not guilty verdict is rendered, whatever the situation may be. So it is to resolve a criminal act and find someone to hold accountable. So the main aim is to ensure that the suspect, the person who's been accused, appears before court. That's why someone is detained. And then it could also be for evidence. But what is presented before the court is information from both the accused, but also the National Prosecuting Authority. And factors that they take into account, obviously, the nature of the crime. The likelihood that if this person is released, they will either commit a similar crime, will be able to tamper with evidence, or be able to intimidate witnesses, or have some sort of negative effect on the investigation. The likelihood of them obviously appearing in court, being a flight risk, being able to not be located, to flee the jurisdiction. The likelihood, I think courts are now taking into account, is the community's response to such a person, whether they're being released. I'm not saying that everyone would be held just because they are in court, you know, that they have some sort of safety issue, but that needs to be taken into account. I think what's also then taken into account is the overcrowding in prisons, and that's not going to necessarily keep someone out, but having someone stay behind for bail or not be granted bail and then be sent to this overcrowded situation where this person doesn't meet any of these criteria does seem to be in a violation of their human rights.
There are categories of bail. There's a bail that is a person granted for petty offenses in the lower courts. There's bail that a person can be granted for petty offenses by law enforcement officers at the police station. There is also bail that can be granted for less serious offenses by the prosecutors in terms of Section 59's capital A. that person can be granted bail by the prosecutors without or before he even appears in court.
I think Mthunzi's video, especially Mthunzi's part of the video, I'm gonna talk to you while I just stop sharing and change over back to our presentation for your viewing. I think it's a nice way of segmenting and discussing the processes around the court. Now, the bail process is one of the processes. Sorry, I'm just a little bit preoccupied. Our technology is playing tricks on us, and we are now going to move over to this section. So the bail processes that Mthunzi and Yvonne were speaking about are all part of what we call that fall under the Criminal Procedures Act. Now, the Criminal Procedure Act is the overarching law that sets out the processes around criminal procedures in South Africa. So everything is determined by this act and how it runs. The revamped court manual does give you a very good understanding of criminal procedure, of the different elements around criminal procedure. But what we wanted to do in this webinar was just give you a few tips in terms of the criminal procedure and what you need to remember. So in addition to what Mthunzi was saying, that bail, there are processes around bail, the criminal procedure also handles warrants and arrests. They handle charging a person. It handles the trial process. It handles the way around witnesses. It handles the way around sentencing. You can all find this in the Criminal Procedures Act. It's set out very well in terms of the different scenarios that can happen in our country and how they need to be dealt with by the arms of the law. It's very important for you to understand this Criminal Procedure Act in terms of when you are reporting on cases, to understand what's happening. Closely linked to the Criminal Procedure Act is the schedule of offences. Now, we heard about the schedule of offences very recently when it came to the Zandile Mhaga cases. Zandile Mhaga case, the alleged parliament arsonist. And that's when we heard that he was facing a Schedule 6 offence. And we thought it might be interesting to talk to you a little bit about the schedule of offences and how they work. Now, according to South Africa's criminal system and the law system, there are 7 classes of offences in South Africa, and they range from a Schedule 1 offence, which is a little bit more of it's not as serious offence, and then it ranges all the way to a Schedule 7 offence. Now, this is a list of offences, and what this list of offences determines is the way that the case will be handled. It determines the bail proceedings and the way the bail can be applied for within the case. So if you think of, it covers everything from an assault, petty theft and an assault, which is often as a Schedule 1 case, all the way to a Schedule 7 offence, which is often terrorism. And so, for example, how does it work? There are, if you look at Schedule 5, there are 19 different offences that fall into Schedule 5. And once again, the court manual, the revamped court manual, gives you a very nice understanding. It gives you a list of all the different schedules and what you can find, which charges or which offences fall under, the different schedules. But you can, it determines murder, and it determines attempted murder, rape, drug offences. Even arson is also in it, as we saw with Zandile Mhaga. What it means is that it determines where bail can be heard. So sometimes you can have, as Mthunzi suggested in his video, you can have a police bail because it's not a serious offence and it can be dealt with via the police. Sometimes there's a bail where it needs to go to a court, and sometimes there's a bail where it needs to go through the DPP. They can make a determination, for example, over a weekend. So the schedule of offences is quite an important determination, because it also helps you understand how to report on these cases and what you should know, the processes that are going to happen when a specific case is going to be heard. So, for example, with Zandile Mhaga, what you can see, for example, in a Schedule 6 offence, it means that the bail application will set out reasons why bail should be granted, why it would be in the interest of justice to grant bail. So, and the onus in this instance is on the state to understand why they should be able to grant bail. Another very interesting matter around the Criminal Procedure Act is to remember that it also talks about witnesses and how witnesses can be subpoenaed before the court if they do not if they are called to come before the court and they do not want to testify, they can be subpoenaed to come before that court. And we've also seen many of those that play out in different types of court cases. I'm going to pause because we're going to go to our next video.
Sorry, Candice, while you're getting the video ready, I just want to answer two questions that I'm seeing. There was one question about the police bail. Yes, you heard correctly. Mthunzi did mention police bail as an option. And this is not for every matter. And Candice does make a good point that, you know, the manual does give a very nice breakdown, but I've got a draft version, it's like gold basically, of the manual. And it does give an example of the kind of thing that you could give police bail for. So for example, any contravention of a bylaw, any traffic offense, driving at speed exceeding the prescribed limit. So if you can see, those are extremely minor offenses. The kind of thing where, you know, you don't want to see someone unnecessarily sitting in jail for a weekend for a traffic offense when the police can give them bail. But it's important to know this as well, because you might find that someone is complaining to you, asking you to do a story about them being denied police bail, for example. Even though they have been speeding or something like that, there would have to be a reason why the police would want to detain them for any kind of minor offense like this. Another question that I saw pop up was regarding the, let me just have a look at it so I can phrase it correctly. Can a suspect be denied due to the schedule of the offense? So I think what was very important from what Yvonne said is that, you know, when the court denies someone their liberty, there has to be a very valid reason why. And that's why, you know, there's often concern about people saying so-and-so should be denied bail just because they are accused of killing someone, or so-and-so should be denied bail because they stole a large sum of money. The court doesn't only factor in the schedule of the offense. That is a factor that they will look at, but they will also look at other things such as, is the person a flight risk? Is there a possibility that they might interfere with the witnesses? That's a very important one. And we have seen people denied bail, for example, because of them either threatening witnesses or witnesses saying, oh, I got a call from someone saying that I'm going to get killed, and they said that they're calling me on behalf of whoever. I think that we saw that, for example, in the Nathaniel Julie's case. It was more to do with not the schedule of the offense, but the possibility of the interfering with witnesses. So the court will not look at one individual thing. It will look at the flight risk aspect. It will look at the possibility of interfering. It will look at the level of the offense. And also, to a certain extent, it will look at the community's concerns or issues. Like, for example, if someone has offended previously, does it make sense to put that offender, now that they've offended a second time, out on bail? So they will consider all of those things. And it will be important for the NPA to bring that before the court. So the court is not going to pluck this out of thin air. The NPA must bring that before the court. And if the person has a defense attorney, the defense attorney will come with a counter view to say, actually, you know what, Your Honor, these things are not real issues. This person has handed in their passport to the authorities. They're not a flight risk. Then the court will weigh up all of those things. And one thing that they might do is, even if there is a bit of a concern about whether the person could be out, the court might increase the bail amount to make it a very high amount, especially when it comes to financial crimes. And that is almost to act as a deterrent for the person to run away. The thinking is that if you have bail of like 100,000 Rand, you're not going to want to lose your 100,000 Rand. So it also acts as the height, or not the height, sorry, the quantity of the bail also acts in a way as a deterrent. If there is little prospect of the person running away, little prospect of interference, also it's a petty crime, then you might find the bail will be set at a very, very low amount of something even like 500 Rand. And the sad part of it is that with the economic state in South Africa, there are a lot of people who have been granted bail, but simply can't afford to pay it and find themselves sitting behind bars as awaiting trial prisoners, purely because they didn't have enough money to pay a relatively low bail amount. So I think the next video that we're going to move on to, and guys, carry on popping your questions into the chat. We're liking this interaction. It's also great to know what you're interested in and what direction you want us to kind of go in. The next video actually involves some tips. We spoke to Karyn Maughan, who many of you know. She's a seasoned court reporter, and she's giving some tips on things that she's experienced in court, as well as we have a bit more from Mthunzi Mhaga, as well as Crispin Peary from the Department of Justice, the Ministry of Justice, let me rather say, and they're just speaking about some things that they've noted that are often either not handled correctly or mistakes that are made.
Thank you. So the thinking is that you would use these tips in your reporting and it'll help you to improve your reporting. So let's go ahead. And just give me a thumbs up if you can hear. If you guys can't hear the video, please just let us know in the chat.
Whether you're covering the trial of a high-profile politician or a land dispute, at some point in your career, you're probably going to have to deal with the civil court application in one of South Africa's high courts. This often involves a lot of court documents, which can sometimes be daunting. We spoke to specialist court reporter Karyn Maughan, who has been covering courts for over 2 decades, asking her advice for those starting out in the field.
Obviously, if you are a reporter and you're on a very tight deadline, your boss is going to want you to just like, what's the point of this? What do these people want? So you really go in there, read the founding affidavit and see, what's the argument this person is advancing. So, Ace Magashule is saying, I want my suspension stopped. I want it, I want it overturned. I feel it's unfair. This is the basis on which I'm arguing that is so. I've been, these are all the problems I have. That sort of substantive stuff is where you're going to find your kind of sexy headline for the story, because that's what's going to draw readers in. And of course, you need to do that quickly. You have a few hours to make that happen. But it is very, very valuable after that to go through the papers. I mean, I've had instances where I found a cracker of a story on like 438 of an affidavit where I've just been like, oh, wow. And the other thing is also to remember that as far as you can, to try and get what are referred to as the annexures in court applications. Because oftentimes people are bringing an application against the president or the government, and then they make reference to communications that they've had and sort of meetings and speeches. And then sometimes, at the back of the court documents, there's a letter between a lawyer for one of the parties and another, or sort of high-ranking official, which is quite explosive. So that's oftentimes where you will get your like amazing scoops, is just by going through those documents.
Karyn was not the only one who engages with the judicial system to dish out advice. Yvonne van Niekerk from the Office of the Chief Justice also advises journalists to be aware of the relevant processes that apply in court proceedings.
I think that sometimes taking the information and maybe understanding not just the law but the legal process, I think is important for all journalists. I think journalists just understanding where we are in the process. I sometimes find that to be the mistakes that creep in is who had the power to make a decision when it comes to things like postponements. Who was requesting a postponement of a case? A judge doesn't just grant a postponement. There needs to be reasons. What were those reasons? Who asked for it? Especially in criminal cases, I find there's a lot of thinking, oh, but no one was prepared. Maybe understanding where we are in the process. I think so understanding process, I think, is important. The second is when media statements are released by the Office of the Chief Justice or a judge, maybe ask questions about that media statement and don't necessarily just print it as is. I know that's sometimes, but engage with the media statement, because sometimes when there's copy pasting from a media statement, things are taken out of context.
Meanwhile, advocate Mthunzi Mhaga from the NPA points out that a common mistake journalists make is in the naming of judicial officers.
Magistrates are judges, and magistrates are magistrates. They are found in the regional court and the district court. Judges are found in the High Court. Justices are found in the Supreme Court of Appeal and the Constitutional Court.
He also advises journalists to be careful when reporting on information that might be revealed in court.
The other problem relates to how the media would then gain access to a statement or witness and bears it out report on it so openly, risking a potential prosecution and compromising that prosecution by going in details in terms of, for example, if there's a confession that they gain access to, they would go into details in terms of those confessions, which then leaves a person at risk. Even some of the witnesses that will be testifying's lives are at risk. I wish the media could at least exercise caution in how they report on the nature of the evidence that the state is in possession of. It's fine to indicate that it seems to be a strong case against the accused. The state will be relying on so and so and so and so, but to go into details in terms of saying that person is going to testify about this and that, saying let's leave that to the court that will determine who is a witness, and to the court that will be trying the matter in terms of which evidence will be accused before the court.
The Justice Department is also a key role player in the justice system, but sometimes it's not clear where they fit into the broader scheme of things. The department is meant to support the judiciary and the NPA, but it must not interfere with their work.
Yeah, so I think, for instance, I know of cases where you would look at operational matters which fall directly within the sphere of the NPA. So if the NPA come out and make a particular announcement, it does not follow naturally that the Department of Justice knows every single thing about that announcement. It would be best to ask the NPA about their own statement and not assume that because they fall under the Ministry of Justice, the department should know what's that. And vice versa. So we wouldn't ask the NPA what the minister is about a particular case, for instance. In the same way, we wouldn't ask the Minister of Justice when does he think a certain case will be concluded. I think that one is.
Having said all of this, at the end of the day, the basic principles of journalism carry through even into court reporting.
I feel for a lot of young journalists because I think they're thrown into the deep end and they end up in court and they don't have a lot of experience. It's very different language. My learned friend this, my learned friend that. You know, the Promotion of Administrative Justice Act, this decision is irrational. It's a very hard world to navigate in. And I think that a lot of times the mistakes people make are because they're on deadline, they're being pressurized, they don't fully understand what's going on, but they take a wild guess. I think that you must know that you absolutely have a right to be in that room and to report. Yes, these people are getting paid all kinds of money to argue hugely important cases, and they're very, can often be quite pompous and what have you, but you are there for the public and you are there to explain things to them in a way that they can grasp. And so you need to understand it. So make sure you understand it, but don't be intimidated. Don't be made to feel small. And if you're unclear of something, seek clarity. The best way to become a very good court reporter is to read. Like, I cannot stress this enough. Read. Like, read the judgments, read the court papers, because you will get more and more immersed in the language. You will see more and more, how does this law work? How do people make their arguments? And you will become increasingly comfortable in being able to take that very dense legal language and translate it into ways that make it accessible to ordinary people. If you have a passion for court reporting, like I do, then you can really have an incredible time getting into the workings of our constitution, of our law, of this democratic state, which so many people fought and died for, and put forward stories that allow people to show how the law works and how it can work in the best circumstances. And it's an honor and a privilege to do that. But to get into that space, you're going to need to just throw yourself into it, ask as many questions as you can, read, and don't be intimidated.
I think those are some nice tips from Karyn in terms of how you really can get to grips with covering the courts and really make a difference. While I flip back to the presentation, maybe I can just ask Dianne to share some of her insights in terms of covering the courts, some of the challenges you experience, and how you, what you've seen as the big issues around reporting in the courts. And maybe we can also ask you, the audience, maybe there are some, do you have any questions around reporting the court, some challenges that you've experienced and how that you want us to navigate that and can answer them. We're just opening the floor for a little bit. We're going to be running about 10 to 15 minutes over due to our technical issues, but we do want to make sure that we cover all the elements of this webinar and that we do give you the full experience. So Dianne, I'm going to hand over to you while I flip back to the presentation. There's also a question that you might want to answer. Sorry, I'm giving you a lot to do, Dianne.
No, it's fine. I mean, you're doing the heavy lifting there with the technical side. I mean, I'm just flapping my mouth. Okay, so I see there's a message here from Faisal asking about the summary of the judgment. So Faisal, I think what you might be referring to is the summary that often comes out from the Constitutional Court, and there is also sometimes a summary that comes out from the Supreme Court of Appeal. But you won't get the summary at all court levels. So for example, with the Magistrates Court is a very in-person experience. I find it to be the least technologically savvy of the different levels of court. Like for example, you won't necessarily find Magistrates Court proceedings streaming online. Mostly we're seeing high court court proceedings streaming online. I think this is something that hopefully the legal system will work with. But if you're looking for a Magistrates Court judgment, you're most likely gonna have to go to the courts to get that decision. When it comes to the High Court, if you've missed the actual judgment, you can oftentimes get it at the registrar of the court, of the judge. So the registrar of the judge is a very important person to get to know. In any case,
can I ask something?
Just give me a minute, Jesper. Sorry,
okay,
let me just finish my point, and then you can ask something. So the registrar of the judge would usually have copies of the judgment, or would be able to email them to you. So once you know who the judge is, you often have to find out who the registrar is. And I found that those details are sometimes available online on the judicial website. There's a website for the department, for the Office of the Chief Justice. In terms of the summary from the Supreme Court of Appeal and from the Constitutional Court, the Constitutional Court is very good about tweeting out when their judgments are going to come out, and then when the judgment is released, also tweeting the summary of that judgment. So I would recommend following the Constitutional Court's Twitter page. It's a very handy Twitter page, but the Concord website itself is a great resource because they post their previous judgments as well as posting documents related to upcoming cases. So they are very technologically sound. And then when it comes to the Supreme Court of Appeal, they also do post some documents online and on their Twitter account. My recommendation would be go onto their website and you'll find that there's an email address for the registrar. Email the registrar of the Supreme Court of Appeal and ask to be added to their mailing list, or follow their Twitter account because they do put the important judgments on that Twitter account. Okay, Jesper, you had a question. I hope I'm saying your name correctly. Jesper, you had a question?
Yes. When you don't have Twitter, can you do it the same? Can you do the same things?
Sorry, just repeat that.
I don't have Twitter, but maybe can you do it with another app, or I'm wrong?
Go to the website.
In terms of getting the information, you can go onto the Constitutional Court website or the Supreme Court of Appeal website. But unfortunately, a lot of court reporting does require you to go physically to the court, especially at magistrate and high court level. If you know who the lawyers are who are involved in a particular court case, sometimes if they're friendly people, they can also help you with accessing judgments and documentation that's related to the court. That's one of the mechanisms that I often use. I'm not a lawyer, but I am a friendly person, yes.
Oh, me too.
All right. Okay, so are there any other questions?
Bye.
Thank you.
There's
Any
a
other
question about sharing too much information about a case while it's still on trial, which is quite relevant. So Mzondile asks, in the Shoba case, they said witnesses must not read or watch the news. Does this mean that we can report everything that was said in court? I think that's quite a nice, relevant question, Dan. You want to answer that?
So in terms of everything that is said in court, unless there's a specific order from the magistrate or the judge, the court is a public arena. That's why they allow people to sit in the public gallery. So what you are doing essentially is you are taking that public gallery and you are making the public gallery a wider space by broadcasting the story further. I think the warning in relation to the Shoba case was much more to make sure that the witnesses don't take bits and pieces from other people's evidence and then include it in their testimony, because that would compromise the kind of the quality of their own testimony. But in terms of your work, if it's said in court and the magistrate or the judge hasn't given a restriction on what can be reported, then you are able to report everything from inside the court. I want to just give you an example of instances where there are restrictions on what can be reported. So sometimes when there's still going to be an identity parade in a case, so they've caught someone, the person is a suspect in the case, the person is not yet pleaded in that case, so they're kind of in that no man's land yet where they haven't actually been charged yet. Sometimes they will still be awaiting an identity parade. But because there's a 48-hour period between arrests and when you must appear in court, usually they'll bring the person to court. And then what will happen is the NPA will sometimes say, please can the details of this suspect not be broadcast as yet, such as the name and the face, until we've actually completed an identity parade. And then the magistrate and or judge would make an order to that effect. So you can then write to say, a person appeared in court, they are going to appear in the identity parade, but you wouldn't be able to include very specific information such as their name is so-and-so, they live in whichever area, or even that they are related to a particular person who might also be involved in the case, because that would also identify them. So those are the kinds of things to look out for in terms of limitations. And of course, I think it is important to remember what Mthunzi said about weighing up the evidence that you're getting outside of court versus what is going to happen in court. I've always found that one to be a very tricky one, especially when you've got people who are involved in the case that are giving you information, and you've got to think, I'm a journalist, this is great information, but you must also think and maybe have that conversation with your editor to say, if we publish this, how will it potentially impact on the case itself? Can it potentially damage the case? And there have been instances where, I've received information and have had to say, have a conversation to say, from this information, this is too critical to the case for us to run at the moment, but we can use A, B, and C because it actually wouldn't impact on the case. So those are important conversations to have with your editor. Candice, do you want us to go on to or just carry on with I think there's a few more questions here.
There are two nice questions there, and one is about when the magistrate when the judicial officer addresses you in the court, should you be responding to them? Let's.
Okay, yeah. So look, it's their house, and you follow their rules, and that's the approach that I think is best to take, right? So you always act very respectfully when you're in court. Also dress respectfully. And this is something that I often see people get a little bit wrong. And I've always considered it as this. You are going essentially into the work environment of legal people. So dress the part. Not necessarily that you have to wear a suit, but don't go in a printed t-shirt, Ed Hardy t-shirt with sequins on it, Dress respectably. Wear a nice plain top. Don't have don't wear a vest, for example. I was in a court case once where it was very hot. I was in Cape Town. It was boiling outside. There's no aircon in court, and one of the journalists took off their jersey and they had a strappy top. The judge stopped the entire court process and told her to get something appropriate. It was very embarrassing, but it was an important lesson. If the judge does ask you something, because it might sometimes happen, like if you've made an application to film in court. Sometimes the judge does ask you further questions. You know, speak to them in a very respectful manner. Some of them are not, you know, particularly particular about how you refer to them, but you can say, yes, judge, yes, magistrate, yes, sir, no, ma'am. See what they respond to. If they correct you and they say, no, don't refer to me as that, then go with what they want. But mainly dress respectfully, act respectfully, because you are in their house and they have the power to eject you if they feel that you are being disruptive. And we have seen that happen where, I think it was in the Senzo Mayiwa case, there were too many photographers, everyone was crazy, climbing on furniture, and the judge said, all of you get out of my courtroom. And it, you know, it was indefensible really from the perspective of the media, because they shouldn't have been acting in that way. And then
is to call them your honor. If you don't know anything, you could call them your honor.
Yeah.
The last question, Dianne, is what's the procedure regarding identity or identifying an accused person? Is it when they appear in court or after pleading? That's a nice question.
Yeah, that's an important question. And I think that it's one of those where there's a lot of debate in newsrooms. My approach has always been, when they appear in court, unless there's a particular reason, as I mentioned before, why you might not be identifying them. The area where this does become a little bit tricky, however, is when it comes to reporting on a sexual offense. And it's one of those things that actually is evolving over time. Now, there's a section of the Criminal Procedure Act, I'm sorry, I don't have it with me at hand, but there's a section of the Criminal Procedure Act that deals specifically with sexual cases. And what it does essentially say is that you shouldn't basically identify the victim in a sexual offense case and the accused. But there are instances where it becomes a little bit tricky, because if there's been a manhunt for until they pleaded, if there's been a manhunt for a particular person, or if they're a high profile person, then it becomes difficult because they've technically speaking been identified in the public arena. So it's a difficult one, because I can't give you a hard and fast answer, particularly when it comes to sexual offenses. But what I will say is, generally speaking, when the person has appeared, because the court is a public arena, you can identify them. However, you must have a conversation with your editor and have further consideration, and you might even need to speak to a company lawyer when it comes to a sexual offense case, because there are other considerations. For example, if the person is related to the victim of a sexual offense case, even though you can identify them, will identifying them identify the victim? Then you must be very careful. So it's the father of the victim. I would not identify the person even after they've pleaded, because you inadvertently then identify the victim. So those are the kind of discussions that you have to have with your editor, and also engage with the Criminal Procedure Act. Like, literally, if you have that problem, go and look at what it says in the act and think about it, because it's not necessarily always going to be a clear-cut rule. But the key thing is that you must be able to defend your decision if you are taken to task. So if you haven't gone and checked, you won't be able to defend that decision. What if the victim of sexual abuse dies? In this case, then we generally do name the person, because it becomes a different matter now. It becomes a murder case, not only a sexual offenses case. So in most cases, if the person has died and there's also sexual assault, you can, a clear example is, for example, the Uyinene case. If she was only sexually assaulted, we actually wouldn't most likely have known her name. However, there was a death involved, and then that became, a bigger issue. And then she was actually identified. So that does change it, and you can name the person who has been killed. I don't want to lose the last part, because I think this is also very important. I'm going to try and just come back to Melissa's question just as we finish here. But I think it's very important to just quickly run through the important documents where you will actually get information, because we really want to help you to be able to get the relevant information for reporting. So in the criminal case, at the outset, oftentimes there will be a docket. There's always a docket. The docket comes from the police station. And it's basically the initial case. What do the police believe has happened? The police will bring the docket to court, and the prosecutor will use that as their initial document. It's sometimes difficult to access, but it's always worth asking while in court, can I have a look at the docket? They won't give it to you, you won't be able to get copies, but you can often have a look at it. And what it will help you to identify is what exactly are the charges that the person is facing. Also, what exactly is the person's name? Sometimes you'll also be able to glean an address where you can sometimes go to get other stories. And it might also give you a sense of whether there's other avenues that the police are looking into. Example being, in the recent Zandile Mafe case, the journalists asked to look at the docket, and that's part of how they found out that there was a new terrorism charge added to the case. So it's very, very helpful to ask to look for the docket when you come for the first appearance. As the case progresses, the docket basically gets converted into the charge sheet. So further, more information comes along. The prosecutor works with the policeman, and they come up with something very, very more concise that actually says what that is. That's the charge sheet. It's always important to ask the prosecutor whether you can see the charge sheet, particularly at the start of the proceedings. Witness statements are also very handy. You might not always be able to get access to them, but usually after the witnesses have completed their testimony, you can ask for witness statement. This is handy, particularly if it's a complex case. So if it's got to do with something that has to do with money and crime, because they don't always go over every single amount. So ask for witness statements, particularly if you want more clear information on what is being said. And then sometimes within a criminal case, there might be an application. For example, if the accused believes that a confession was forced out of him, his lawyer might make an application to the magistrate and or judge to say this portion of the testimony shouldn't be included, or this statement shouldn't be included. They will oftentimes write up a bit of an application within the court proceedings. If you can get access to that, it will help to explain much more clearly why they are calling for either a certain bit of evidence to be dropped or anything like that. Candice, can we move to the next one? And this is the last slide, I promise. In civil proceedings, some important documents, the notice of motion, that gives you the initial grounding of the case. What exactly are the people asking for? If it's an application, for example, brought by Ace Magashule to have his suspension overturned by the court from the ANC suspension, there should be a notice of motion. And it's a bullet points basically explaining what's the key stuff. He wants a suspension. Does he want a monetary compensation? Does he want, whatever it is, it will be in the notice of motion. Then you will find a number of affidavits which are very important to go through. The founding affidavit gives you the initial case, and that's usually brought by, if it's an individual, it will be brought by the individual. So Ace Magashule in a case that he's bringing. But if it's an organization, the organization will give someone in that organization permission to depose that affidavit. There'll be a replying affidavit from whoever is being challenged in the civil case. Then there'll be a replying and then a responding affidavit. It's good to read all of these affidavits because it gives you the different aspects of the case. I will say, I believe this person wronged me. Then the other person will come and say, no, actually, I didn't wrong them. And then the applicant will have the opportunity to reply again and say, actually, this is why I say that they wronged me. Annexures, as Karyn mentioned, are very important because they often have minutes. They sometimes have documents from an organization. They sometimes have financial records. And in the affidavit, they will mention, they will mention a summary of what's in the annexure. So go through the affidavit first. Then when you get to the parts where you're dealing with annexures, you'll be able to identify which annexures you want. You might not want everything, but read the affidavit carefully and note which annexures might be of relevance, and then try to access those either via court or via the lawyers in the proceedings. And then heads of argument, these I find are always very helpful, especially when it comes to constitutional court cases, because sometimes there's a lot of participants in a case, but the heads of argument will really give you the summary of what everyone is actually saying. And Sometimes if there's many people, if you get the heads of argument, you'll be able to actually get a clear summary to say, okay, this person is arguing for this, but this is the counter argument. And then you'll find also other people like amicus curiae, the friends of the court might come with other supporting arguments. So heads of argument are also very key documents to look out for in civil proceedings. All right, sorry, Candice, I see there's a message here. We are going to wrap in, I think, the next 2 minutes. Unfortunately, we can't answer all the questions, but I think there was one important question about when the manual is coming out, and maybe this is a chance for Hopewell to just respond, unless you have an answer on that, Candice.
Yeah, I think Hopewell, I was about to, I did type a message in the chat to Nico, but just in case you missed it, Nico, in case you missed what Hopewell said at the beginning of the chat, the manual is being printed. It's also being developed into an online manual, and that will hopefully be available in early March. The manual should be available online and you'd be able to access it on the SANEF court portal. Hopewell, please feel free to add on any additional information. I don't know if you're still on the call, if you've managed to stay on, Hopewell. I'm
still here. I did stay on, my lady. I should just, you just mentioned all, but people should know that it won't be end of March. That will be touch, I suppose. I would say in the next 2 weeks, it will be up on our website. So we apologize for the delay. We had thought by the time this webinar starts, we will have all the portal material up there. So humble apologies. Sometimes January is just bad in terms of getting things done.
I think as long as they have access to the manual shortly, it would be good. In the meanwhile, you can also access the previous webinar and this webinar on the IAJ's YouTube page. I'm sure the IAJ will send out a tweet that just directs you to that YouTube page, and it will also be available from this site. So if you have missed the previous webinar or parts of this webinar, you want to watch the videos again, you can access it via the YouTube or the IAJ's channel. Just to also remind you that this is the second of 5 webinars that we are running around reporting the courts and the relaunch of the reporting the courts manual. Our next webinar is going to happen on the 16th of February, and the title of the webinar, I'm going to get my notes, is The Role of the Judiciary and the Office of the Chief Justice in South Africa. We thought it would be a very helpful webinar since we are having the Judicial Service Commission hearings in the next week. So following from that process, you'll be able to chat and get some context around the Office of the Chief Justice and the role of the judiciary in South Africa. And obviously, if you have any questions around that, you can send us an email, you can pop it onto the IAJ site, and you can prepare them for the webinar. You can come and chat. It will be a panel discussion. We'll be having some live guests on the platform, and it'll be really nice to engage with them about their experiences around this topic. So please register for that webinar and be part of the entire series, and you can catch it. Following the webinar on the 16th of February, we'll be having a follow-up webinar on the 17th of February, which will be reporting on children and other vulnerable groups. And the final webinar in our series will happen on the 24th of February, and that will be on covering commissions. And we hope that that will then give you good insights into how you can improve your reporting around the courts and the court systems in South Africa. Guys, I think without further ado, that is it. Hopewell, unless you want to add any final remarks, if you want me to hand over to you,
No, I'm done. Thank you so much.
Perfect. Dianne, any final remarks from your end? I know you spoke so much. I think you've used your entire 1,000 words for the day.
I just want to say thank you everyone for participating, and hope to see you again in the next one.
Perfect, guys. Thank you so much for your time. With that, I'm going to close off the webinar, and we'll see you next week. Thank you so much. Well, next time, not next week. Tishan,